Commissioner Stevens?
Here,
For me, please.
I'm sorry?
here,
Commissioner Lopes?
Here.
Commissioner Lee?
Here.
Commissioner Wilson?
Present.
Commissioner Murphy?
Present.
Commissioner Founds? You're on mute.
Here. Sorry about that.
Thank you. Commissioner Peterson?
Uh-oh, I think he froze.
I think he's glitching.
Well, he is here. I'll say here on his behalf.
Okay. Commissioner Satter?
Here.
And Commissioner Cantonwine is not here.
So it looks like we do have one person in the audience tonight. Rick Cook is here, who some of us know. So hi, Rick. Until Tom's tech gets worked out, I think the first thing is just the study session, correct? That's where we're sorry, I don't have my agenda open at the moment. So I think we can go ahead and turn it over to our consultants and potentially to Joy Fields, who's project managing this project, and we can get started with the study session.
hey, Jennifer.
Yeah.
Do we not want to start with public comment?
Oh, sorry.
That's okay.
Yes.
I think that's why Rick's here. So that was the only reason I brought that up.
Sorry. Okay. Darcy just made me the host. So, and I think Tom might be back now.
Back now. My computer's acting up, so I'm on my iPad now. So always got to have a backup plan.
Perfect. Well, I was going to skip right past the public comment after noting that there was somebody in the audience, but we should do public comment. That's where we are.
Okay. Thank you, sir. Pardon. Sorry about my technical difficulties here. So at this point in the meeting, there's an opportunity for anyone in the public that would like to comment on an issue of concern. Unless it's on tonight's topic, there'll be possibly an opportunity to comment during the study session if you have anything you want to say. So does anyone want to address the commission at this time?
I have Rick Cook with his hand raised in the audience.
Okay. See, will we get bringing him on?
I'm trying. It's not giving me the option.
Oh, I bet it's because you turned it over to me.
Oh,
Here we go.
There you go.
all right. Well, I'm going to sign out then. You guys all have a good night.
Yeah.
Darcy.
You have a nice holiday. Probably won't see you between now.
Oh, thank you. Merry Christmas.
Yeah.
Yes.
Have a great holiday and New Year.
Yeah.
Okay, so we're ready to go?
Yeah. So we have some public comment. So
Yeah, I do, and I'll just try to get through it real quick. I know you guys are busy, and first, I want to thanks for putting the public comment first, and also thank you all for all the work you've done over the years and volunteering for being on this thing. It's so important that you guys do the great work that you do. So I just noticed that on tonight's sessions was the ZDO piece and standards and stuff, and I just wasn't sure if conversation I'd had with Jennifer a while back, maybe that they would do it, but it doesn't look like it's on there tonight. But just curious if anybody from the commissioners or any of the staff members that were at the Eugene Association of Oregon Counties conference past couple of weeks ago was able to go to one of the sessions, and it was on grid expectations, energy capacity, and future legislation. We've had a situation out here in Stafford where the substation at Rosemont Stafford Road, they were looking at maybe putting in a battery energy storage system, which is short BESS. And I know that Washington County's been battling, I shouldn't say battling, they just had a hearing at the end of October about that and situating it in a rural area, a rural farm area out there. And they were having some concerns about that. And knowing what our past situation was with the power lines that we've had out here, and that the county code may not have been where we needed it. it's a concern, and I want to thank Jennifer because we had a conversation about it, and I just wanted to kind of check to see if we've had any updates on that, or probably bring it up to your attention if you didn't know about it, and the fact that Marion County actually has put a moratorium on any of the battery pieces in there, and it's not that a lot of us out here are against the battery storage thing. We're against the lithium batteries that you can't put out, and they've had numerous. They've had five fires in the West, Arizona, California, a couple other places in the past, just this year alone, and these all the facilities that had issues were all under 4 years old. So there's a big concern, and I know that I feel so sorry for our planning staff because I know they're overworked and understaffed, and this is just something else that we don't want to put on your platter, but it's coming. We know it's coming, and we just want to find out a safe and healthy way to do this because there's other things other than lithium batteries to do. So with that, I will kind of leave it in there, and that's kind of what I was curious about.
So I guess this is a question in light of your concerns, a question for Jennifer. Given our zoning ordinances, if I can't remember, is it PG or PPNL? It's that provider out there.
PGE.
PG. Okay. If they wanted to put in a battery facility, would it go through us, or is it allowed under a conditional use?
So it wouldn't go through you regardless, because those type of, any sort of site-specific uses like that don't come to the planning commission regardless of what that they are.
Right.
Whether it's allowed under our code is probably something that Rick thinks maybe no. We've had a little bit of back and forth, and that's fine. I think probably yes, but I can't say so for sure. We don't have anything in our code that says battery energy storage system. That's not a specific thing that we have as a listed use. We did a lot of work, many of you will remember here a couple of years ago, that Rick was just alluding to regarding various types of utility facilities and the big discussion about transmission lines and all of that. So we have updated our code relatively recently, but we did not specifically speak to these battery energy storage systems. So the question would be, what would they be? I suspect they would be classified as a utility facility, but I'm not going to say that that's explicitly clear. If they are a utility facility, then they would be a conditional use permit in many zones, meaning that it would go to our hearings officer for the decision, of course, with notice to neighbors and all of that. In an exclusive farm use zone, of course, those uses come to us from state law, and it would need to be processed as what's called a utility facility necessary for public service. That's a particular classification in EFU. Counties are required to allow those with just the standards that are in state law. Again, it hasn't really been tested. Some counties have approved, I'll call them BESS under that category. Some, I think, have called them power generation facilities, which I think that's what they are. So suffice to say, there's not 100% clarity, but I think there's probably a pathway. There also was some legislation this last session where they did explicitly add, I believe, a definition of battery energy storage system and incorporated them into some other energy statutes that relate to certain uses where an applicant can request to bypass the county's land use process and go directly to what's called the Energy Facility Siting Council, or EFSEC. Our county doesn't have a lot of experience with that. A lot of my colleagues out in Eastern Oregon deal with this all the time. We really haven't had experience with that process. It's my understanding that EFSEC is supposed to apply the county's local code. Again, that's what the folks in Eastern Oregon are telling me, but that potentially they really don't, or maybe they don't do a great job of it. So, but that would be out of our hands. The developer has the choice to just do that, based on this legislation. So I think, yes, there's some questions. I think what Rick would like is for some specific code standards addressing this use specifically. And we do not currently have that.
Okay. So this could either be addressed through a code standard, which would essentially mean the county commission would have to kind of delve into this topic and determine if they're going to allow battery storage. Are they going to condition what types of batteries would be acceptable and what types of batteries would not be? Essentially, is what I'm hearing the issue is. Is that a fair statement?
I think that's what Rick has shared, is that yes, the lithium batteries are a particular concern.
Yeah. Well,
Yes.
yeah. Too, as well. Okay. Well, so if I'm understanding it correctly, there's really not any action on our part unless we want to initiate something. A recommendation to the commissioners or something like that. Is that what I'm hearing?
Yeah, the planning commission under our code does have the authority to initiate a code amendment.
Okay.
That would be something you do on your own motion essentially, and would require a quorum, which you do have tonight. I think probably we'd want to put that on an agenda and be a little more open about it, even if, it's not that we would need to do public notice for it, but I just feel like if you were going to take that kind of action, we should probably at least put it on the agenda. But you could do that. You could technically initiate the code amendment. The way that it's worked that's been something that hasn't really happened often, if ever. And at the end of the day, of course, the board does direct staff resources, so you could initiate it, but it wouldn't necessarily go anywhere. I can't say for sure. The other thing you could do, of course, is just simply make comments to the board, which we could share, saying, hey, you've got these concerns. But either way, you could do that. The board is aware of the concern. Rick has definitely been has sent some email correspondence to them, and I do know that our director, Dan Johnson, did share the back and forth that Rick and I have had via email with the board's office. So at least should be somewhat on their radar. But at this point, staff hasn't been asked to start any code amendments.
Okay. Well, and I would agree with you. This obviously would take a fair amount of research and before we would be in any position to make a recommendation. So it's not something we would necessarily that I'm suggesting we act on this evening, but I guess it's something for us to think about going forward. And I guess we could maybe do an informal poll of the other commissioners to kind of see what their feelings are about maybe a follow-up session specifically on this topic or not. And I don't know if we want to do that now or if we want to do that offline informally. I'm not sure. First time we've had one of these where it's prompted a potential action item on our part.
We have some questions, Tom.
Yeah. Oh, okay. Thank you. My screen isn't working very well, so I just saw the hand come up now. Thanks, Tammy.
Mm-hmm.
So I'm on my iPad, so it's not as I don't see everything as well as I do on my computer. So thank you. So you have a question?
I think Murph was first.
Murph was first? Okay. I don't know why I can't see those. Murph?
I just wanted to make a comment that I have a couple people from the Hoodland CPO that are trying to get in to testify, but it won't let them in. But they wanted to take advantage of the public comment.
It won't let them in? You mean the link won't?
The link won't. I just tried it too. It won't
The same thing that Rick Cook had a problem with. Can you get their emails, Murph, and then we could email them a link?
Okay.
Can we not, Jennifer?
If somebody can't, I'll have to look. I have the panel. I just have my personal panelist link that Darcy sent me. I don't know if I have the general meeting link.
We might be able to send them the link Rick used.
Oh, there we go. Maybe Rick could email that link to Jennifer, and then Jennifer could use that link. Rick, will you just email Jay I just type it automatically. JENN, I'm sure he's got your email.
Yeah.
Oh, he
Okay.
did. Yeah.
Yeah, shoot that link to Jennifer and then we can get those 2 emails from you, Murph, and then Jennifer could shoot those links.
Okay.
Okay, so my hand is up while we're working on this to get
See
those
that?
folks on board, but just in talking with Rick, because I have talked to Rick, and why it's a bit on my radar, this lithium issue, is though, I think it's a great idea. If we're creating massive amounts of solar via, massive amounts of energy via solar, we got to store it. I mean, we got to store it so we can use it. But what I'm learning is these facilities require a lot of space. And I'm not talking like a big building. I'm talking like acres. So it's going to have to be, again, what I'm hearing. I'm not the fact finder. I'm just the listener. It's going to take acres of property. So this might be a concern for rural areas. That's number one. And then it isn't just the fact that they can catch on fire. It's that you can't put them out. You have to let them burn out. And those fumes are very toxic. So those are it is a serious health and safety issue. I'm pretty confident that's probably why Marion County is saying until the health and safety issue is addressed, that they don't want it in their farmlands and things like that. So I think this is an important topic that Rick has brought. And I, for one, would ask for some more information for this planning commission to make or not make a recommendation.
Okay.
Okay, thanks.
Anyone else on the commission now that I can see the hand raise function, anyone else on the commission have anything they'd like to share? Commissioner Wilson, I see your hands raised now.
Yeah, I'm not familiar with this storage issue, but I'm kind of curious as to, maybe Rick can tell us what's so important about this. Why is it needed, and what are the advantages of it?
Are you still on, Rick?
Oh yeah.
Okay.
It's it's used everywhere. There's companies. Texas has, oh gosh, probably more than 50 of them, and it's a storage area where during off hours, they store the energy, and then when it hits a higher use rate, then they kick it in and kick it into the system. So it supposedly helps average the time out and use out, and as much data processing and mega things that are going on. A lot of this stuff is going out towards Hillsborough because they have so many AI data processing places out there that they're using those in. So, and I don't know all the particulars, but the piece that they have is there's different things you can use other than lithium. And that's our biggest concern, because you can't put a lithium fire out.
Yeah.
You got to let it burn. And the one down in Moss Landing is going to cost them, I think the latest estimate was $360 million for cleaning it up afterwards. So,
it's going to become a bigger and bigger issue in this country because of the proliferation of data centers, and there's not sufficient energy sources to power all these data centers. And so there's a big push for wind and solar and all these renewables. The trouble is they don't provide power at will.
right.
So the power companies need to have a way to stockpile that power and then use it when they can. I have a good friend who's an energy trader, so I know a little bit about the dynamics. But the reality is there is so much solar at times being generated out of California that there's not any use for it. But in the evenings, when the sun's going down, there's this tremendous amount of need for energy. So it's a way to balance the loads and take advantage of the renewable sources. But it's going to mean a proliferation of storage facilities, because in the past, most wind and solar installations just sold the power to the utilities without any concern or obligation to deal with storage. It's a utility problem. So that's why a lot of these facilities, when they weren't developed, the storage wasn't built into the actual facilities. Now there's a proliferation of these facilities, and now it's becoming a big need. So it's going to be a really big deal. I get it. And you're absolutely right. We need to make sure we do this in a thoughtful way where we're using storage facilities that don't present new problems and new environmental issues to the public. It's kind of ironic when you think about it. You have a renewable clean energy source, yet the way you store it is a very potentially hazard kind of a mechanism. So you kind of wonder if are we really making any progress here?
And just very quickly, the lithium ones are cheaper to install, but they don't last as long as the other ones. I don't know. There's an iron piece, and I don't understand it, but they are safer things to do. So with that, I appreciate your time, and sorry to take up so much of your.
No. It's a good topic, and I think it sounds like it's something we may ask for maybe a follow-up discussion item about this topic, and it will kind of. I'm hoping that we'll kind of get a sense where the commissioners are as well. So we might want to send a talk about it later in the meeting about maybe suggesting to the county commission that we look into this a little bit more and see what their reaction on, which then might lead to some action on our part. So we'll see.
Thank you all so much.
Yeah, thanks for bringing it up.
So Murph, did you see that link to send to your?
You're on mute.
You're still muted, Murph. I don't know.
We're having technical difficulties tonight for some reason. I started with me.
Yeah, I was just in a 2.5-hour meeting with DLCD, and my brain's melted a little bit. Sorry, I'll get this.
So you got the link though to send to
I
your.
did get the link.
Okay.
Okay.
Perfect. All right. Well, there's nobody else here at the moment besides Rick. So.
Okay. Well, what I suggest, let's jump into the study section, and then perhaps at the end of the meeting, if anyone wants to propose suggestion to the broader county commissioners about this topic, we can talk about it then. Does that sound fair? Seeing no comments, so let's move forward. So we get to talk some more about clear and objective standards. I can hardly wait for round 2 here. So Jennifer, you want to kick it off?
I think we'll let Joy kick it off, or the
Okay.
consultants. I'm not sure which. I'm not
Okay.
sure what their plan is exactly between the three of them.
Well,
All righty.
I was just going to welcome everyone and say that I look forward to the discussion tonight and the direction that you all give us, and hand it over to the consultants who will be primarily driving tonight's meeting. There are a few maps that I may speak about directly that were generated by staff for this project. And so you may hear from all of us tonight. With that, Kathy or Kate, although I see Murph's hand up once again.
I just want to let you know, CPO, the Hoodland CPO did just get through, if you wanted to hear them. They've been very patient.
So they have.
There's
Public
Marty
comment?
Bound on.
Yeah, Marty Barn.
So do you want to take, and they want to make comment, Murph, is that correct?
Yes, they do. Yeah.
Do you want me to go ahead and do that, Chair?
Yeah.
All right. So
As long as it's
sorry,
not on,
if you could pause for a second.
as long as it's not on the topic of the study section.
It's on the, it is on the, what we're working on.
It's actually okay because we don't take comment during the study session. It's just if we're having a public hearing that we ask them to wait.
Okay. Well,
I'll
you're
go ahead and bring Marty in.
makes sense to me, but I was just reading the notes.
Oh, yeah. Sorry. That's Supposed to be changed. I guess it got changed back.
Sorry. Thank you for.
Okay.
patience.
All right. So thanks, Murph. So who wants to address this again? I'm sorry, I missed the name.
Marty, and I've let them in. So
Okay.
Marty, you can go ahead.
Hi, it's Marty, and I'm on the board of the Hoodland CPO out here. And we're very interested in being able to help you guys. I mean, we have a lot of knowledge about the Upper Sandy Basin up here, and I'm also chair of the Land Use Committee of the CPO. We have a lot of knowledge about land use up here. We have a lot of knowledge about why we're different than everywhere else in the county. We're not anything like the Willamette or the Tualatin. We have the wild and crazy Sandy River up here. We have some real concerns about how this gets rewritten. 291. Yeah.
Okay. So in terms of how you can help us, what do you have in mind?
I'm just going through 704 and seeing where things maybe need to be explained in more detail. There's a lot of confusion and kind of geriatric or general terms being used in there that probably should be tightened up.
Okay.
Yeah.
Well, here's what I would propose. Tonight's a study section, so we're not really acting on anything. And so what you're going to hear tonight are some of the options or suggestions of how they might address the zoning ordinances. And so what I would propose is, you're going to have the benefit of listening to the study session as well as our comments. And I would propose that you send us your concerns or comments based on what you're hearing tonight. And just if you could send those to the planning staff in writing, then that'll all then get to our attention eventually when they move towards actually making the final recommendations. Would that work for you?
Absolutely.
Okay.
Yeah, I'm working with other members of our land use committee, and I know Murph personally, and I'll probably run a few things by him before I submit it to you. So thank you very much. Appreciate it.
Great. Well, we appreciate your input. So
Thank you.
anxious to see what you have to say.
Thank you.
Thank you for joining us. Anybody else? Oh, Tammy, you had a question?
I just figured while you were bringing the PowerPoint presentation back up, there were just a couple things I wanted to say really fast. First, I had no concept in the world how I'd ever get my arms around this. This is so big and complicated, but this summary that I read was incredible. I mean, I don't want to wait to the end. I want to say it now. The kudos to really getting the pros and the cons and addressing each topic. This helps so much. I can't tell you. And I'm excited to actually go through the PowerPoint and make it come alive. The other thing that I want to be clear in my mind, because I'm not clear, if you have ordinance A and ordinance B, and they're similar, they have the same topic, but each have sort of different rules or how you do things, can we not take, let's say, the one that is the best is ordinance A, but B has a couple good things. Can we not take some of the things from B and put it into A? I mean, because it kind of looks due to the pros and cons that we can't do that. So it would help before we begin the process of addressing each one to understand whether we can do that or not.
Okay, so you're kind of jumping ahead into the actual item.
Right.
Okay. So if I think I understand what you're trying to say. I guess I was thinking these are probably going to be specific to each one.
Right.
And so maybe at the time we're addressing the item that we maybe have that conversation as opposed to try to do a general comment about it at this point.
Okay, sounds great.
For each one, it's going to be probably different.
Oh, okay. That would be great. Thanks, Tom, or Commissioner Peter. So.
Yeah. Okay. All right. Are there any other folks in the public that would like to address us before we get started with the study session? Are we all done?
In the audience? No, that's all.
Okay. All right. Joy, we'll put you back on. Or it looks like, I see Kate's coming up, so it looks like Kate may be.
It's Kate's turn.
Okay, Kate's turn. All right. Take it away.
All right. Thank you so much. Good evening, commissioners. Yeah, we're happy to be back here talking again about the Clear and Objective Code audit and update. And again, just really digging into some of these kind of bigger policy questions and hoping to get some direction from you all as to whether you like some of the potential suggestions that we've included. We included, as Commissioner Stevens said, in that additional packet of information that we provided, some kind of concepts for consolidating code sections, for streamlining, simplifying, kind of trying to remove places where they're really overlapping or redundant code sections, kind of bringing things more up to date. So, just as a reminder, this is, of course, a follow-up to the last Planning Commission study session. The first meeting, we dove into the code audit findings and kind of some of those details of all the places where we identified conflicts with the clear and objective requirements in statute and some potential concepts or solutions for addressing those issues. And then today we're here to really dive into the discussion and really hear from you all as to whether you like these ideas and you think, yes, please move forward with making these amendments to the ZDO, whether you think maybe we should hold off because you have some concerns about the potential changes to the code, or, you know, another alternative is we like this idea, but maybe we want to spend some more time on it. Maybe we don't have time to accomplish this as part of this current project that we're working on with the county. Maybe we want to put it in kind of the parking lot of things that could be addressed in a future effort. And of course, we're presenting some kind of yes or no questions, but these are not necessarily like discrete options in every case. There might be some kind of in-between option, as Commissioner Stevens suggested. So that's something else to keep in mind. So the first kind of set of discussion questions, code concepts is around consolidating ZDO sections. And these are kind of in three general topic areas: water resources. Of course, there's a lot of code language around protecting water resources and related habitat. The whole section of natural features, ZDO 1002, is kind of getting a closer look as well. And kind of similarly with the open space and parks section, ZDO 1011, looking at options for kind of simplifying and potentially consolidating those sections as well. So looking first at the water resources sections, and here we're going to kind of refresh your memory about some of these issues. We're not going to repeat everything that was provided in your code, in your agenda packet for tonight, but kind of highlighting some of the issues and definitely highlighting the pros and cons to consider, and also taking a look at some maps to kind of help provide some context for the issues and kind of highlight, you know, what some of the trade-offs and considerations might be. So the first question is around consolidating the water quality resource area, or the WQRA, with the Habitat Conservation Area, or HCA, or sometimes referred to as HUCA. I think I might just say HCA requirements. So these are both regulations for wetland and riparian areas. They both apply within the metro urban growth boundary and service district boundary. There's a little bit of a difference, though, where the WQRA, the water quality regulations, don't apply within the area that's subject to the Clackamas County Service District number 1 surface water management regulations. So that's a little bit of a difference between the two, but otherwise these are both kind of urban area regulations. The WQRA requirements implement Planning Goal 6, which is air and water quality and other aspects of environmental quality, and also the Urban Growth Management Functional Plan Title III requirements, whereas the HCA habitat regulations implement Goal 5, natural resource regulations, and Title III of the Metro Functional Plan. So there's a lot of overlap, but there's a little bit of a different emphasis between these two sets of regulations. So this is just kind of a snippet of where these regulations apply. So you can see the green area is the habitat conservation area, and the kind of hatched blue is the WUCRA water quality areas. So as you can see, there's a lot of overlap between the two. And I would say this is true for most of the areas where these apply. There's mostly kind of overlap between the two, but as you can see, there are some water quality areas that aren't included in the HCA inventory. So that's something to keep in mind. It's not 100% overlap, but kind of in doing a rough review of the sort of geographic applicability, a lot of the areas where there's water quality but not habitat, I mean, in this case, these kind of appear to be sort of existing developed areas where they might be kind of like water ditches, water channels that are not necessarily sort of high quality resource areas. And again, this is just one teeny little snippet. This is obviously not showing the full extent of these where these areas apply, but just something to keep in mind. Of course, it's not 100% overlap. So in terms of the considerations and the pros and cons of this approach of consolidating these two sets of regulations into kind of one section, of course, they have the same general applicability of inside the Metro, UGB, and Service District. The inventories are mapped by Metro. In addition, by the Department of State Lands, which maps the wetland areas that are not necessarily mapped by Metro. As I mentioned, much of the water quality areas also fall within the habitat conservation areas. And I mean, I think the big benefit is that a single overlay district would make the code a lot easier to use by staff and by applicants who wouldn't need to kind of deal with two sets of kind of confusing regulations. But some of the cons, I mentioned that the water quality regulations don't apply within that Clackamas County Service District number 1 boundary. And so within those areas where that CCSD number 1 boundary applies, that an applicant or a property owner would still have to deal with kind of an overlapping set of regulations of those surface water management standards and the HCA habitat standards. And then another big potential challenge with this approach is that it would eliminate the ability to add new water quality resources to the inventory if they're found during the development review process. So currently the habitat conservation area regulations really depend on the mapped inventory, whereas the water quality regulations, there are maps that are part of the county's resources, but then it's really based on kind of the definition of a wetland. So if a wetland isn't part of the map, and if we kind of move to this more clear and objective, streamlined approach, you wouldn't necessarily have the opportunity to add new wetland inventories to the habitat conservation merged kind of section. I see we have a question from Commissioner Stevens. Go ahead.
So this would be an example of the question I asked prior. Because we've experienced that where we've had stuff come to us and then because the county doesn't map every wetland, but then it did apply. There was a wetland that was discovered or a part of a land use. Can that then now be added, even though, I know I'm not asking this intelligently, but what I want to say is it eliminates the ability. Can we add that ability to and maintain it?
It's hard to add that in a clear and objective standard way. That is my quick response, Kate, and I apologize for jumping in. But a lot of the standards in the habitat conservation area are more clear and objective and provide a uniform pathway that applicants can follow and understand what the mitigation requirements are and the application requirements are. But having the ability to add an unknown wetland is not clear and objective.
Okay,
So
now
how do it would be difficult to do that using 706 as the base of the clear and objective standards.
But are there not clear and objective standards when they originally mapped that they utilized to map them? I mean, we couldn't use those objectives here. I guess I'm just asking because I mean, they created maps. They had to come up with what went on that map.
And yet we still find unmapped
Yeah.
wetlands
We do.
that are addressed through 709.
You're right. Thanks, Joy. Yep.
709. Oh, Sue's water quality.
Sorry, yes. ZDO 709 for the water quality resource area. Kate, did you have anything to add to Tammy's?
No, I think you pretty much summarized it. I think the issue is that the water quality regulations really rely on kind of words to define how a wetland can be identified, but those words are not clear and clear and objective. Whereas the habitat regulations really depend on a map, which says, you know, either you have this on your property or you don't, which is a clear and objective standard. So that's really the challenge.
And I would assume it would be a horrifically large project to do a more detailed mapping of Clackamas County wetlands.
Yes, you are correct.
Okay. I mean, you don't want to give it up because there's been wetlands that have been protected that weren't mapped. So I'm scratching my head on this one, but thank you both very much.
And before we get to the other comments, just one thing to add, which we've mentioned before, is that the wetlands that are not necessarily mapped currently. They would be regulated by the Department of State Lands through their kind of separate permitting process. You have to, you know, receive a permit from DSL to develop on a property that has wetlands on it. But the regulations are not necessarily equivalent to what the county would regulate with the water quality standards. So something to keep in mind as you think about that.
Commissioner Murphy, I see your hands up.
Thank you. Yeah, so we're not talking about delineated wetlands, are we? That have already been delineated and identified. We're talking about wetlands that just exist due to sediment identification, or how do we identify these wetlands that we're talking about? Is it by plant life, sediments? Are they significant wetlands or non-significant, or do we know? Because that's how the state looks at it. So I'm curious if we could align with the state's terminology on this, if possible.
And my general understanding is that even the state's terminology is not necessarily clear and objective. It's kind of a discretionary process identifying these features that may or may not be kind of significant or non-significant wetland areas. It's a bit of kind of a squishy process that if you're allowed to have kind of discretionary language or not, you know, perfectly clear guidelines to identify those areas, then that's totally okay. So through the DSL process, it may be okay to have that kind of less clear and objective approach to identifying wetlands, but within the confines of a development code, they need to be clear and objective as applied to housing.
And would they have a timeline on identified wetlands, or are they do they have a expiration time on them?
Does the DSL permit have an expiration?
Well, I just learned that delineated wetlands with the state have a 5-year expiration and they have to be redelineated. So will Clackamas County be following that same? I mean, I guess they'd still, if they were delineated, they'd be under state law, right?
That is true. Yeah. I'm not sure if Joy, you know the answer to the expiration question.
I don't know the answer to the expiration question. I was going to read the section to answer Murph's question. In 709, .02, there is a section that says if credible evidence, for example, aerial photographs, topographic maps, or expert studies, indicates that the subject property may contain a WUCRA that is not identified on the WUCRA map, then Section 709 shall apply.
Okay, so it's not hydric soils.
No.
So Murph, let me just respond a little bit. So the county did do a wetland inventory, a local wetland inventory in the 1990s as part of periodic review that was accepted by Department of State Lands and ended up being the basis for an old version of Section 709 that doesn't exist anymore. So those were not, I don't know how specifically they were delineated, but they were delineated to the point where the state said, yep, this is a local wetland inventory. So I don't know exactly what all the steps were, but there was definitely some field work done, and county had a consultant that did all that. And then there was a whole process where we determined which ones were significant and were going to be protected and which ones were not. All of those wetlands were supposed to be on the Metro mapping. About 95% of them are. But there's what'd you say? Would we find, Joy, 2 or 3 that are missing? 3 that are missing. So conceivably those could be added, for instance, as yes, these really are mapped and maybe we can just adopt that in some way. But I think the problem is this sort of nebulous, oh, if we find something else, we'll just decide we're going to regulate it, is problematic given the new landscape with clear and objective standards. Or the not so new landscape in some cases.
Okay, interesting.
Okay, I have my hand up. I have more of a process question about what you're looking for from the Planning Commission on each of these topics. So you've laid out the pros and cons. I'm assuming you would like some, or maybe not. Maybe it's just another conversation and you're going to listen to our comments and come back again with maybe more specific recommendations. I guess I'm trying to make sure I'm clear on what you hope to get out of this session from the commission. So, for example, for this particular topic, do you want us to kind of do a general consensus as to whether we're in favor of the pros, or no, we think maybe the cons outweigh the pros, and so we don't really think you should pursue this one. I'm just for clarity, so I can make sure I'm managing the meeting appropriately. So, and I'm not sure if yes, okay, is that helpful?
Yes, that's very helpful. Yeah, I mean, I think it's sort of up to you if you want to do like a straw poll or something for each of these. We weren't necessarily expecting that. I think these are sort of preliminary rough recommendations so that if we don't hear major concerns from you all, then I think we will proceed with these, at least for the first draft of code amendments that we'll, of course, bring to you for review and further discussion. Okay. And of course, if we hear major concerns, like please, pump the brakes, then we would maybe want to reconsider. But I see Kathy has her hand up, so maybe I'll see if she has other thoughts.
Kate, I was only going to add on to what you're saying, which is, yes, I think we are looking for somebody to say, oh gosh, no, those cons look really significant, and to check in with us if you think they're kind of overwhelmingly negative. But I also think hearing like the interest in wetlands and exploring ways, for example, in this case, if we consolidate, is there a way maybe to continue to protect wetlands that would not or like make sure we look at what the solutions are for those, that's a concern. I mean, we're hearing, at least we're getting that in the notes, we're hearing that. And so as we step away and go to think about the draft, it's like, okay, well, consolidation works, but there's a concern about, ensuring protection of wetlands going forward, and make sure that we have a solution for how that's going to happen. Is at least kind of what I'm thinking the kind of the takeaway from that message is.
Yeah.
So I guess if you wanted a more unified set of directions from the Planning Commission, but I think we can kind of hear what your concerns are and
Okay.
take those.
Well, I guess from what I'm hearing is we don't necessarily need to kind of go, we support this one, we don't support that one. That the concerns that are being raised will be factored in to the next round where you'll have maybe more specific recommendations than what we're seeing today. Is that a fair statement?
I think that's right, but I think the recommendations will be in the form of initial draft amendments to the code. So yeah, not just, I mean, we might come back to you with kind of a summary of the changes that we've made.
Okay.
But yeah, I think that's correct.
Well, I'll throw in my 2 cents on this one. This one's a tricky one. As we're listening to it, it's like, and I can't say how important it is to maintain that ability to, if we find a new wetlands or not. But others may feel more strongly about it. But my reaction is to this one is, well, yeah, I think in principle it makes sense to consolidate, but there is this issue of how do we make sure we don't lose some ability to make sure we're protecting wetlands and in the process. And I mean, that's kind of what I'm hearing. So that's kind of my takeaway as well. So,
Okay, appreciate that.
anyone else have any comments on this section? No?
Would it be helpful to just also type in the chat?
Sure.
Do you like that? Okay, thank you.
I'm assuming everyone sees the chat. Jennifer, you're on mute. I see your hands raised.
I just wanted to agree with you, but one of the biggest struggles when you're doing like planning commission that I've come across is the things that you didn't think of. So it, trying to cover all your bases ahead of time can be hard. So if we put ourselves in a position where we already know there could be an issue, then we might be paying for it later.
Yeah. Good point.
Just another thing to kind of throw out there is that, we are only required to have clear and objective standards for housing development. So another opportunity is to, and this maybe makes the code a little bit more complicated because we'd have to have different regulations, but you could keep what you have for everything that's not residential. And so, you could keep the kind of discretionary opportunity to add wetlands to the inventory for non-residential, but for housing applications, you would need to have this clear and objective path. So that's another thing, kind of middle ground in a way.
Although it seems to me, if we're going to go to this effort to have clear and objective standards, why would you just focus on one aspect of development? We should apply to all, not just be focused on one aspect of. It would be my personal opinion, but
yeah, I think that's the general sentiment that we've heard from staff, as well as a desire to not kind of add to the complexity by having different regulations for different types of development.
I would agree with that personally. That just seems like it makes it more. We really didn't achieve our objectives if we have two different standards.
Mm-hmm.
Okay. All right. So I think you heard our concerns, and so I'm assuming you will take those into consideration as you move forward with the next steps on this particular topic. So if you want to move on to the next one, why don't we go?
Absolutely.
All
Okay,
right.
great. So the next topic is rivers and streams again, but now we're looking outside of the urban area. So we're looking at rural areas that are outside of the metro urban growth boundary and service district boundary. And we're considering consolidating ZDO 1002.04, the river and stream corridor section, with the ZDO 704 river and stream conservation area, or RISCA regulations. So similar resources protected by these both of these sets of regulations, similar geography. They do implement slightly different statewide planning goals. So the RISCA regulations address both goal 5 and 6, the natural resources and water quality, whereas 1002 only really focuses on water quality. But again, kind of similar types of resources and intent behind both sets of standards. We included some maps just for general context. These are not the county's adopted maps, so I don't want to focus too much on these, but just wanted to give you a sort of a general sense. This is kind of a basic GIS layer showing streams, kind of unspecified streams. And then this next one is showing fish-bearing streams, which is generally aligned with the RISCA regulations. That's kind of the set of maps that the county relies on, is kind of an earlier version of the fish-bearing streams inventory prepared by the state. So as you can see, if I kind of flip back and forth between these two, that most of the streams are considered fish-bearing streams and would be regulated by RISCA in this portion of the county, at least. This is kind of generally true when I kind of zoomed around the county. But there are some streams that aren't necessarily captured in that fish-bearing streams inventory. So there might be some areas where there are streams that could be regulated by one set of regulations that aren't regulated by the other. So, and that is kind of our chief con of this approach of consolidation, is that it would eliminate the consideration of those non-RISCA streams for avoidance and protection during discretionary land use reviews. So these 1002.04, the river and stream corridors section, at least in practice, the county has only applied those regulations during discretionary land use reviews because the language is pretty vague and pretty discretionary. So that's kind of the context in which those regulations have been considered so far. But on the pros side, again, these both apply to rivers and streams in rural areas. Consolidating these two sets of standards would remove redundancy. It would provide better clarity and standards for when and how river and stream corridors are protected, and would make the code simpler. So there's a lot in the pros category, but then there's this kind of outstanding issue of what about these maybe kind of minor streams that wouldn't be mapped as fish-bearing streams? Would those be kind of left out of the process? So these are the considerations. We don't necessarily know how big of an issue this is. Like, we don't have a calculation of how many streams are in existence, but that would not be part of the RISCA inventory. So can't necessarily answer that question if you have it on your mind, but there might be a little bit more mapping work that we could do to try to find that if you're interested. But otherwise, I'll open it up to kind of general questions and comments.
Commissioner Murphy, I knew you'd going to raise your hand on this one.
Yes, I could go on, and I won't, but I would, because we just heard from the Hoodland CPO, they'll have some comments on this to write. They're paying attention. But to do away with the protections, for what we consider seasonal streams that are showing salmon lately in our area. So I have streams that are dry a couple months out of the year. Fall rains come in, salmon are moving up them. And this is year after year lately. And I don't want to shoot ourselves in the foot by taking away protections on these streams if they're starting to show a salmon recovery because of a dam removal or because of habitat restoration projects. So I don't know. This is going to be a tough one to work around. You know, today could be a learning, or next couple of days is going to be a learning experience on the Upper Sandy, possibly too, for
Yeah.
why we setbacks. So we'll see.
Just one thing to point out with the Sandy River is considered a principal river, so that Sandy would of course be regulated by the RISCA regulation. So those protections would remain. It's really, as you mentioned, these kind of intermittent streams or seasonal streams that or just smaller features that aren't on the county's adopted inventory that would be potentially left out. And I think the challenge is that adding new mapped resources to the inventory is kind of a whole other process that, of course, we can't undertake as part of our work. We're just kind of code nerds. We're not we're not environmental scientists. So that might be something that you want to consider in a future effort if you want to kind of expand the regulation of those streams. But I don't know if county staff want to say anything about how the 1002.04 regulations have worked to this point, just for context.
So I guess one thing I want to point out, just maybe it's obvious, but because we were talking about the urban ones, I do want to be a minute ago. I feel like this discussion is very similar, right? The Hukka and the WUCRA being combined, it's a very similar sort of policy dilemma as this, just one's urban and one's rural. But one big distinction to make is that wetlands in the rural area are not regulated by the county, with the exception of a few up at Mount Hood that are in the villages at Mount, like Welch's or Government Camp. Other than that, we don't regulate wetlands in the rural areas. So it's less of a, maybe less of a policy decision, but still these streams, I think the answer is, for the most part, they haven't been really regulated, because if somebody's coming in to build an ag building or to, add a garage to their house, we're not, historically, have not been applying these standards because they are so incredibly vague, and there's never really been an application process established for it for longer than I've worked at the county. But for applications that have gone through land use review, like say a subdivision, or maybe somebody's going to build a school, or they're going to, build a church or something like that, we've been able to find these, that aren't on our inventory, but that exist, and have in some cases applied buffers to those. So I don't want to say that we've never protected something through this process, but I do think it's been kind of hit and miss, I guess.
I have a comment if no one else does. So to your point, Jennifer, this one strikes me as very similar to the first one. Is there but fish-bearing streams is perhaps a little different dilemma. Is there a process that monitors streams to determine, what may currently not be a fish-bearing stream, but in the future it might be? Is there a way that any process in place that tracks that, and where those can be updated or not?
So the maps that we used as our inventory for Section 704 are technically they're Oregon Department of Forestry maps, but I believe they were done in conjunction with Oregon Department of Fish and Wildlife. Then staff's gonna be meeting with ODFW about something else soon. But Joy, in our research, or your research, I know that those sorry, I'm not saying this well. I know that the maps that Oregon Department of Forestry produced have been updated over the years. So yes, there is a process that they are refining those over time. I don't know the details of how often or how they do that or what. The problem has been that, at least my understanding, is that Goal 5, which is what this was intended, 704 was intended to be a Goal 5 program, requires you to have an inventory that you adopt which means every time ODF changes the maps, we don't get to just start applying those. Like it requires a whole other, and we've never done that. So the maps that we have technically adopted are the ones from the 90s. And so every time a new iteration comes out, then in theory, the county could, I guess, go, refine its inventory and all of that. But that's not something that we've historically done.
Okay. So that's something to think about it too, isn't it? I mean, it might just think here. It might be that some of these new current objective standards may dictate a need for periodic updates, mapping and things like that. So you wouldn't necessarily worry about the fact that the new standards, you don't have that flexibility. Well, you may be able to introduce a policy that says, oh, well, whenever they update these maps, and we need to go through and update our maps accordingly so that our maps are now current with the current lots. And then your current objective standard would always be applicable. Sounds to me like it may introduce some future work if we really want to stay on top of things. So.
Yeah, believe me, I'm wishing that had been done for the last 30 years as we've been embarking on this project.
Well, yeah, I mean, yeah.
For sure. Because, this sort of backlog of, boy, we really should have done X creates a lot of questions now about what to do.
Uh-huh. Commissioner Wilson, do you have a question? You're on mute. You're still on mute.
Okay. Geez, where'd I put that? Can you hear me now?
Yeah, you're on. You're on now. Yeah.
Okay. Going back to what you were talking about, updating the maps. Why can't we just use the maps and not have to update our maps?
Good question.
You mean, why can't we just use the state's latest maps?
Yeah, I mean, it sounds to me like we're making extra work by using a map and then updating our maps to match that map. That seems like a waste of time.
I mean, we would technically use their maps, and that's available now. Now, it wasn't in the 90s, but now we can get it as a layer in our GIS system. So technically speaking, it's not hard to use the state's maps. What's hard is we have to send those little postcards to all the people who weren't regulated before and say, guess what? You now can't do things on your property that you thought you could do. And that's the hard part. The hard part is that whole public process of telling people that we're going to restrict their property rights, and the fact that people tend to get pretty concerned about that. So it doesn't mean we shouldn't do it. It just means it's something I at least have to keep that in mind with every one of these questions is and there's more coming. Like this is just the first or the first couple issues, there's other ones on this list. And every time we make a decision to say we're going to do new maps, new whatever, we're regulating new people. And that's what gets hard because we have to go out and have that conversation. And that may or may not be required as part of this project. I mean, in some cases it may be, but in some cases it's an optional thing. And that's something that you and and the board ultimately have to decide to sort of weigh that out about adding new regulations.
So let me see if I understand this. The state comes out with a new map that's going to change something in the maps that we have that is going to restrict some property owners or whatever. But we're not passing that on to them. So we're kind of not following the law just to make sure that the public doesn't complain about it. Am I missing something here?
Well, I wouldn't say we're not following the law. We aren't following the law right now regarding clear and objective standards. That's what this project is for. But our Goal 5 inventory for streams was acknowledged in the 1990s, and we've never been required to adopt a different one for the rural area. urban area, yes, we did that. That's now habitat conservation areas. But the rural area, we haven't been under any requirement to update. But by not doing that, we're disconnected a little bit maybe from reality now because the maps have changed over time.
So I'm really confused here. So we have some state regulations that don't really apply to the rural areas that we have. Am I missing something there?
When ODFW updates their map to include new streams, it's not tied to a change in state law. It is just tied to, they have new data on topography and soils and geology that indicates there's a stream there they didn't know about. Or there's a survey that shows there's a stream there. It's not tied to an Oregon revised statute or an Oregon administrative rule that then requires us to update our maps to reflect this change. So there's been lots of updates to the fish-bearing streams in Clackamas County since we adopted the maps that we adopted. The maps we adopted are legal. They were based on the best data available to us at the time. That is what we have protected for years. However, through this process, we have this question of, for the last 30 years, we have had two different pathways of protecting river and stream corridors. That's confusing and not necessarily clear and objective for all property owners to understand or follow. Should we combine them? If we combine them, then this new and better data is not used as we regulate stream and water quality.
Wow. Just okay.
I mean, really, if I don't know, this is really complicated. I'm not saying it's not, but I think the policy question, and you're going to get asked this in a lot of other topics, is, do we do the minimum of what we are required to do to come into compliance with this clear and objective standards work, recognizing that we're going to not protect everything that we could potentially protect out there? And the flip side is, okay, no, we're going to do more than the minimum. We're going to adopt new maps. We're going to regulate more people. We're going to go out and have that conversation with the public. That choice is going to face staff, you, and the board in probably at least a half a dozen ways through this project. And we're not trying to say it's not valuable to protect these areas, but we are not also, I'm never going to say it's going to be easy to do it.
Well, I understand it's not going to be easy to do it, but what I'm saying is what we're trying to do is we're trying to protect some water quality and some habitat areas, and we should be doing that to the best capability that we can, and that would be whatever the new maps show, that would be the way I would think that we'd want to go. I mean, that was the intent of those maps.
I think that's the dilemma, Michael, is that it's exposing the fact that we maybe weren't protecting them as well as we could have been. And now going forward, do we want to, now that this issue has come to light, do we want to say, wait a minute, we need to, while we're doing this, we also need to make sure we're really, doing our best to make sure we're protecting these areas as best we can. But
what Jennifer was saying, these are 30 years old.
I know. It's exposing.
Geez, it's 30 years old.
Yeah, I know. It's exposing a big gap. I'm with you. Therein lies the question: how do we, going forward? Well, we, as well as the planning or the county commission, will have to kind of decide. Okay, there's a new issue here now. We have to wrestle with. How do we want to approach it? So, Commissioner Murphy.
Thank you, Tom.
Yeah.
Isn't water, when it's in a stream, a Oregon resource? And isn't that protected by state law?
The state owns certain rivers.
There you go. So what we're talking about is the buffers, right? We're talking to the county regulates up to the mean high water mark.
That is the protection that 704 provides, is a buffer that is spelled out based on the size of the stream, is 50 feet, 75 feet, or 100 feet.
Department of State Lands regulates the water and what goes on in it. Unless it's a navigable river, then it's Army Corps of Engineers, if I'm correct.
Or if it's the Sandy River and owned outright by the state.
Yeah, well, Sandy's navigable from just below the Brightwood Bridge down because of comments.
Right.
So just for clarity. Thank you.
Do we have, Catherine, you wanted to?
I was just going to clarify. I think the waters of the state is within the mean high water, as you pointed out. And we're often talking here about the riparian area and the riparian regulations. So that's a little bit different. And so again, I think we're talking about, primarily statewide planning goal 5, which has, either a safe harbor for protecting riparian corridors, or a jurisdiction can do an inventory and an ESCE analysis and then reach a program to protect, right? So you can, in the case of riparian corridors, you can follow a safe harbor, or you could, have your own program. And of course, the county's program, I think, actually predates the current Goal 5 rule. So it goes back a ways. But, I think what I'm hearing here is there's a lot of concern about any kind of law, like are there ways that in a clear and objective manner, these headwater streams that are not necessarily protected by 704, it's fish bearing, can retain some level of protection, even if it's not even if we're limited in how it can be applied to clear the residential development, because of course with residential development, it has to be clear and objective standards. But for a land use, like I think Jennifer mentioned the example of a school or something like that. So where there's an opportunity, it sounds like what I'm hearing is there's some strong feelings that we try and retain that. So either by not consolidating, or we consolidate, but we find a way within that consolidation to try and retain that protection. And I think is that getting some head nods?
Yeah,
and I think we can try and take a closer look at opportunities to do that. And, we'll work closely with staff to do that, but to try and to thread that needle and find those solutions where we can. I mean, obviously we have, we've got to have clear and objective standards for residential development. So, but we can see what we can do for other types of development, or where the solutions might lie. Does that, Jennifer, Joy?
Yeah, I think so.
Right.
I think you're hearing the general theme. It's like, okay, we get it, but there may be some other considerations, or it may introduce some new policies that the county may choose to enact to make sure some of these issues are addressed in the future as needed. It's kind of what my takeaway. It's
right.
And I think hopefully what this next step, we can come up with some of those based on what you heard. You can come up with some recommendations that says, well, here's one way you could address it. We do the clear and objective standards. However, if you're still concerned about this, then perhaps the county ought to implement a policy that updates the maps, or whatever it might be. I'm thinking something like that in the future might help us come to a better recommendation as well. So right now we're just raising all kinds of red flags and for you guys
This-
to wrestle with. So
Yeah, no, this is exactly what we needed to hear, though. Look,
Yeah.
where are the Planning Commission's priorities? What's important as we go to create that first, and again, of course, you'll see a draft and it's going to be very preliminary.
Right.
And you can also, when you see it in context, you say, wait a minute, that doesn't solve my problem.
Yep.
Like these amendments, right? So
Yep.
Yeah, absolutely. Okay, well, that's very helpful.
Okay, well, in the interest of time, why don't we, I think we got the general gist of what the concerns are. So why don't we move on to the next one and so we can get through all this tonight.
All right, thank you. Yeah, I should mention that I think we're less than a quarter of the way
I know.
through the slides.
I was
We
well aware
do-
of that. That's why I suggested we move on.
Yeah. I mean, we did try to kind of put these in the order of priority or sort of biggest questions first.
Yep.
So I'm assuming we probably won't get through everything, but it would be great to at least get through a lot of it.
Yeah.
Okay. Moving on, next question is around the Willamette River Greenway, ZDO 705, and specifically the buffer requirements. So the Willamette River Greenway regulations, there's a lot of different types of standards around public access to the river, recreational use, scenic views, things like that. Specifically, though, we're looking at the buffer requirements because this is where there's a lot of overlap. So the idea is to consolidate those buffer requirements that are within the rural area outside the urban growth boundary, to consolidate those with the RISCA regulations that we were just talking about, and then within the urban area to combine those with the habitat conservation and water quality, or maybe a consolidated version of those two sets of regulations. Because there's, again, a lot of overlap between sort of the applicability of those regulations and the Willamette Greenway standards. And specifically in ZDO 705, there's a minimum setback and a vegetative buffer or filter strip requirement. The range is between 100 and 150 feet. The regulations are not clear and objective, so they need to be updated. But I think one approach to that would be this consolidation idea. So this is just a snapshot of some of the areas where this is inside the UGB. So this is showing the kind of green dotted line is the Willamette River Greenway boundary. And then the green habitat conservation and the blue hatched, it's kind of hard to see on your screens, but the water quality areas. So as you can see, there's quite a bit of overlap. There are some places where the Willamette Greenway boundary goes outside of those HCA and WQRA regulations. But really the kind of buffer area, the 100 to 150 foot buffer area is actually a little bit closer to the river. So I think these maps are a little bit deceptive in that regard. But then looking outside of the urban growth boundary, there's not really an overlapping set of regulations there because the RISCA doesn't currently apply to the Willamette River. It applies to other principal rivers like the Sandy River in the rural area. But so the approach here would be to kind of add the Willamette River as a principal river that could be regulated as part of the RISCA regulations. So that's the idea, consolidate those where possible. Again, removing redundancy, making the code simpler. Some of the cons here, though, are some of the provisions of the Willamette River Greenway would be retained. For example, the dock standards, or could be retained. So that the changes would put the Willamette River standards in two sections of the code. So instead of all the Willamette River stuff being in one section, there would be some over here. The buffer requirements would be in the RISCA or in the habitat conservation regulations, but then kind of everything that's left over that's not a buffer regulation would still have to be in this Willamette River Greenway section. So not necessarily simplifying in that way, although it would be simplifying specifically that kind of buffer setback requirement. And then the habitat conservation area is generally narrower than the Willamette River Greenway, as you saw in some of those maps that I showed, which could potentially complicate the process, but it wouldn't necessarily prevent that consolidation. And just to point out, the habitat conservation kind of buffer is wider in some areas. Okay, So let me pause there, see if there's any questions about this one and if you have any thoughts.
Commissioner Wilson?
Maybe Joy can answer this question. Why was there a difference, 100 or 150 feet?
It is almost the exact same as the buffer around principal rivers that are subject to the regulations in the RISCA section of our code. The principal rivers, like the Salmon and the Clackamas rivers and the Molalla River, have a 100 to a 150, and it depends on the topography and the vegetation and other characteristics that are not clear and objective. And so it looks like they borrowed the language from the principal river, or maybe the principal river borrowed the language from the Willamette River Greenway. It it seems as though 150 is what it was, and we elected to go larger than that to protect the viewshed, but not necessarily the buffer. So it's a way of the Willamette River Greenway on the map is a lot of times wider than 150 feet on either side of the Willamette River. And that allows us to regulate the height of structures and to facilitate public access if the property is larger and can facilitate the public access. The buffer, the water quality aspect that mirrors the RISCA, is limited to 100 to 150. So by only dealing with the buffer, we're not losing anything. We're adding the Willamette River as a principal river and continuing to use that same buffer requirements that the RISCA has. And we get more clarity on what happens if there is disturbance in that 150-foot buffer. How do they mitigate for that? That would come in through the HCA requirements that are clear and objective. Right now, when we look at an application and they say, we need a vegetation plan, staff are like, what is a vegetation plan? How many plants is that? Is there a spacing? Is there a mix of shrubs and ground cover? And so there's some lack of clarity in the current standards for the Willamette River Greenway that by mixing it with the RISCA for just that buffer and the buffer requirements, we get some clarity and answers to help applicants.
So what I'm hearing is whoever's deciding whether it's 100 or 150 listens to what the plants are going to be, some other factors that are coming in there and say, okay, it's going to be 150 or no, it's going to be 100. Those rules and whatever code or whatever it is you're trying to use there are not spelled out.
Not under the current regulations, which is why we have to spell them out now.
Okay, so what we're talking about is spelling them out to say if you have 15 plants that are going to be between your house and the river, you're okay for 150. If you only have 3, you're 100. Something like that?
If you think back to our meeting last month, we talked about the principal river regulations being set at 150 for the non-discretionary pathway, and then having a potential discretionary pathway for disturbances that are between 100 and 150 feet. That would likely be what you see for the Willamette River Greenway standards as well. The clear and objective pathway is you don't develop within 150 feet of the mean high water line. If you want to hire a consultant or a habitat expert and a landscape architect to design plans that would meet the water quality and and visual aesthetics that the Willamette River Greenway provides, then you might be able to go up to 100 feet, depending on the topography and the specific conditions of your site.
Okay, so based on your experience, what do most people want? 100 feet?
They want to get as close as possible. But again, the clear and objective standard, if we're protecting what we're protecting now, yeah. So we will see, but that based on previous discussions, that is where it looks like it might go if you're
Yeah.
supportive of this.
Okay, and so that 100 feet is also not infringing upon their having a flood or something like that that's going to destroy the property or the home or whatever structure they have there. Is that what we're using?
Floodplain regulations are outside of this.
Okay. Okay.
Yeah.
Yeah.
It
I'm
seems
good.
like,
Thank
yeah, it seems to me on this one, if I might jump in, that the where we're headed is what Joy proposed, a more stringent standard, but a mechanism to be closer if they follow certain procedures is probably what she's saying where we're headed. And it seems like that's a little easier one to address than the previous two as an approach. So that's my take. Anyone else? All right, want to move on to the next one, or is there anyone that needs to take a 5-minute break before we jump in, move forward, or are we go ahead? Or are we all okay to keep plowing ahead? Keep going. Okay, Tammy's saying, go. All right.
Okay. All right. Let us know if we need to pause. Next section is looking at natural features, which is kind of looking at a bunch of different types of natural features and resources, ZDO 1002. Okay, and so we've got concepts for consolidating various sections within 1002 into different sections of the code. So this first one is looking at ZDO 1002.01, which is the hillside regulations, and consolidating that with 1003 hazards to safety, and specifically the mass movement hazard area regulations. And so these areas are kind of similar, but not quite the same. So the hillsides, that refers to slopes of 20% or greater. So just based on slope, whereas the mass movement hazard area regulations apply to mapped areas of land movement, slump or earth flow, and mud or debris flow. So of course you can imagine there are more mass movement hazard areas in sloped areas, but just because you have a steep slope doesn't necessarily mean it's a land movement area. These regulations apply countywide, so there's no kind of urban versus rural divide here. 1003 implements Goal 7 of the statewide planning goals. 1002 hillsides doesn't seem to be tied to a specific statewide planning goal, or maybe it did in the past, but it had been, or that the overall section maybe did in the past, but this one specific section is not goal related. Okay, so quick rough map. I believe this is the correct map layer. Well, actually, this is close to the correct map layer. These are actually 25% slopes in that kind of pink area. We didn't have specific data for 20%. So the 20% slope area would actually be a little bit wider, 20% and above. And then the landslide hazard area is that kind of hatched area. As you can see, there's a lot of overlap, but it's not the same geographic area. So that's kind of generally the type of applicability that we're thinking about. But the idea here, and there's a lot of similarities in terms of sort of the type of analysis that you would have to do to develop in these two different types of areas. And especially in even more steep sloped areas, you would have to submit a geologic study prepared by an engineering geologist or a geotechnical engineer to say, you know, you can build in this area and it would be safe. And if you need to mitigate, here are the strategies to make sure it's safe. So I think it makes a lot of sense to kind of try to combine these. And the pros are, of course, removes redundancy, changes would make the code simpler, kind of similar theme here. But on the con side, by retaining only the hazard-focused standards, the regulation of steep slopes just for natural and scenic purposes would be eliminated. So I didn't mention that, but part of the hillside regulations are not just related to kind of preventing hazards or preserving, you know, safety of property and lives, but also to preserve the kind of natural and scenic qualities of those hillside areas. But because that is highly discretionary language and really open to interpretation and kind of difficult to enforce, I think enforcement through application of those standards has been kind of spotty over the years. At least that's what we've heard from staff. So it hasn't really been implemented consistently so far. But by removing kind of those scenic area, removing that specific language, there would kind of be no opportunity to regulate hillsides just on the basis of scenic quality. And Joy or Jennifer, feel free to jump in if you have anything to add to that, but these are kind of the main trade-offs to consider.
And Commissioner Murphy, I see your hand raised also, as is Commissioner Stevens.
Yeah, I just have a question. This doesn't really line up with our comp plan in chapter 3. It talks about a 15% slope. It's 4 times greater in cost than 0 to 8% slope to develop. So it's almost pushing for, I mean, it's not even going near 20%. It's bringing up 15%. And that's chapter 3, page 4, bullet point 5. If you want to take a look at it, they won't be aligned, so to speak.
I can't speak specifically to that, but does that section of the comprehensive plan say that those areas should be slopes of 15% or greater should be regulated differently than other areas?
Well, the way I'm reading it, Kate, it's talking more or less, it's kind of frowning upon going beyond 15% slope. From what I can see, it's trying to say in cost, it costs too much. I don't know. Take a look at it, see what you
Okay. Thank you.
Yeah, I'll have to look. I'm not aware that there's a prohibition or, on developing on slopes that are less than, which might be different than other, we talk about, like, for instance, density in prior to middle housing, density in the urban area. One of the guidelines for determining what zone you applied was slopes. So in steeper sloped areas, theoretically would be zoned for lower density. So there are other ways that, the comp plan may capture concerns about slope, but I don't think it's a development prohibition, but we can certainly look at that language and see. The question here, I really think, is whether we want to attempt to preserve sloped areas for their scenic value above and beyond the hazard concerns.
Right.
Because the code's been doing both for all these years. To a greater or lesser degree of success, but it has been attempting to do that for years.
Gotcha. Commissioner Stevens, you had a question?
I honestly am fine with the natural and scenic not doing that. I mean, if somebody owns a hillside and wants to put a house on it, if it's safe, they should have a right to do that or whatever. So I'm okay with that part. I just want to make sure that the hazard focus standards are not only if it's above 20%. I mean, if a LiDAR map says this has historic landslides, then we're not building on it. I mean, that's mega vital. That is such not only a health and safety issue, but it's really important to understand if you lose anything to a landslide, there's no insurance. No, absolutely no homeowner's insurance will cover landslides. And if you get it through Lloyd's of London, you will pay half of the value of your home annually to get that insurance. So this is one that I just want to make sure that we're not saying it has to be over 20%, that it is anything that Dogamian, the LiDAR maps say has historic health and safety danger. And so that's my only comment on this.
And just to respond to that, yeah, you're right. We would not be changing how that applies to those mapped landslide hazard
Okay.
areas.
Great, thank you.
Commissioner Wilson?
Just a curiosity question. How old are those maps?
Good question.
We're going to get to that actually if we get through the entire presentation. They're really old. The slope data is not a map. Like we can use whatever data we can have available. So that's not an issue. But for the landslides, the county's been regulating to maps from the 1970s for 50 years. And there are newer maps that Department of Geology and Mineral Industries has produced, like Tammy's talking about using LiDAR, and the county has not adopted those. So that is a significant question for this endeavor. The other thing I will say is Commissioner Stevens mentioned not allowing them to build. Our code doesn't say you can't build. It says you have to get essentially a geotechnical engineer to tell you how to build safely, and then you have to build according to those requirements. So unless the engineer was to say, no way, no how, you can't do it, we would currently, our code would allow you to build as long as you follow the guidelines from the engineer.
Okay. All right. On to the next one.
All right, great. The next one is the combining ZDO 1002.06, the Mount Hood Resource Protection Open Space Regulations, and 1011 Open Space. So two different sections of the code. They both address open space areas mapped within the Mount Hood Community Plan, so the Mount Hood Village areas. So section 1002.06 addresses water quality in those areas addressed or designated as resource protection open space within the Mount Hood villages. And then section 1011 also regulates, but uses sort of different language, regulates wetlands in the Mount Hood Community Plan area. So this is just an example of one of the maps that shows wetlands. This is the Government Camp Village Plan. So this is just an example. We don't have kind of a updated GIS layer for this, but this is kind of the type of map and resource that we're looking at. So some pros and cons here with consolidating these two sections, and the exact mechanics of how these would be consolidated is still kind of to be determined, but we don't know of any cons so far. Maybe you could identify some for us, but really we're looking at similar resource areas and similar types of protection. So we'd be removing redundancy, providing better clarity and standards for when and how these resources are protected, and would make the code simpler. So we think this is pretty straightforward, but let us know if you have any thoughts or questions on this one.
Seems like this one makes a lot of sense to me, but anyone else have any thoughts or comments? No? Okay.
Oh, great.
Go to ZDO 1011.
Awesome. Okay. Looking at other aspects of the open space and parks code section. So the idea here is hopefully to either remove or consolidate all sections of this open space and parks section of the code. So in addition to the Mount Hood Community Plan mapped areas, these regulations also apply to areas identified as open space on the North Urban Area Land Use Plan map. So that kind of northern urban area. And in this section, the resources are divided into high priority and second priority open space. And high priority open spaces need to be preserved outright, although What exactly that means is not totally clear. And then the second priority open spaces are regulated more on a case-by-case basis and using discretionary criteria. So that's really the issue that we're trying to deal with. But all of the resources, especially in the high priority open space areas, have a lot of overlap with other, natural resource and goal protected areas regulated by other sections of the code. So the Willamette River Greenway, hillside areas, rivers and streams, flood hazards, etc. So the idea is to kind of rely on those other sections of the code to regulate those resources instead of this open space, a little more vague kind of discretionary section. One thing to point out is that if we are removing these open space regulations, we would also need to make amendments to that comprehensive plan map, which is where those areas are designated. So that's another kind of procedural step that would need to be undertaken if you want to go with this approach. So this is an example of in the urban area, kind of showing the open space resources are outlined in black. Areas that are part of incorporated cities are in gray, so those are kind of blocked out. And then this is the urban area, so we're subject to the water quality regulations and the habitat conservation area regulations. So this is to kind of point out that a lot of the areas that are identified as open space are already regulated by those other sets of standards, but there are some areas that are open space that don't neatly fall within kind of the habitat conservation area. So I think you would potentially be losing areas that would otherwise be subject to these open space requirements. But because the requirements, again, are very discretionary, it's not totally clear how they apply or what the effect would be. They haven't been as useful over the years from our understanding.
We have a couple of maps to showcase that.
Hmm.
And I don't know if you want to share those or if I have the ability to share.
I imagine you do. I could stop sharing if you want to share, Joy. I think I have them pulled up on my computer though, so I could switch over.
Okay.
Let me see if I can try to do that.
As a quick comment, these maps are really helpful.
Oh, good. Is this the one that you're thinking of, Joy?
This does show what I was wanting to show, the larger map. It may help to frame the first conversation piece. So the map that you all just saw did a great job at showing the habitat conservation areas and the water quality resource areas, but there were some areas that we wanted to highlight. One of those are parks and natural areas and schools, which are the schools are this gray piece. Some of the areas in the last map that you saw that are included in the protected open space layer are actually schools. And have been protected. Other areas are already protected as parks. So these lighter yellow areas are parks and natural areas exactly. Like that area has been protected as a park or natural area. And then there's homeowners associations at the very top of the map. In that purple area there is homeowners association that is protecting that piece of the natural or of the open space protection area. So the circular orange blobs on this map are the mass movement hazards that have been mapped by Dogami. The dark red are the steep slopes. So if we consolidate the open space layer with all of the other hazards, water resources, habitat that we have talked about tonight, the only areas not protected are those in purple. Now, if we go to the next map, you'll see that some of the areas in purple are already developed in subdivisions, like the one in the Altamont area. That includes a park and a homeowners association. It includes habitat conservation area in green. It includes the steep slopes in red. But in that purple area, which is the open space layer, it has been developed. In other areas, like the southeast Aldercrest area, that purple layer still retains a lot of trees. That could be outside of other protected areas. Like in the top right there's urban forest there. So by consolidating it, there is some resources that would not be protected. But as you can see from these three examples, the way that the open space protection overlay has worked in the past has not protected those resources outright. It has still allowed subdivisions through the planned unit development process, and it's still allowed some development to occur. And so that is the piece that I wanted to add as context for the conversation. So you can, unless someone has a specific question about these maps, I am done with my little soapbox.
Thanks, Joy.
Commissioner Murphy, you have a question or comment?
Yeah, I'd just like to know what happens to the resources that will not be protected.
Turn into homes.
It's auction? No, I'm just kidding. But are they protected under Metro?
If they're not public park land, then yeah, they wouldn't be protected. And, if they're outside of the habitat conservation or water quality areas, then they wouldn't be subject to Metro regulations.
So does notification have to go to these neighborhoods that these resources are going to be not protected anymore if we decide to lift protection?
Not individual notice. We have to send individual notice if we're going to protect something we are not currently protecting, which is probably going to be the case with some of these changes that we're talking about, that we'll have to notify people that we're potentially adding restrictions to their property. The law requires that. We aren't required to do individual notice to tell people that we're removing restrictions. We notify CPOs, those kinds of things, but not those individual like postcard mailers.
And just one more question would be, how many of these properties are public land that have these resources will let go?
That's what the orange and gray, or not orange, yellow and gray show. So these tan areas are the parks and natural areas or homeowners associations.
I see. So the resources will be on private land.
Yeah, we actually did a rough calculation in GIS of that question of how much of this is public land, and it's about 80% of the land that wouldn't be regulated by the habitat conservation or water quality resource areas. We didn't look specifically at like the landslide hazard and those other regulations, but 80% of those areas outside of those other regulated areas are private property. So they wouldn't necessarily be protected just because they're on private land. But a lot of those areas are already developed, so they wouldn't be subject to additional protections one way or another.
Were the development restricted to some point to maintain that open space classification?
Oh,
If
you mean
the-
sorry. In the
Go ahead,
past,
Jennifer.
Murph, is that what you mean?
So within the open space areas that were zoned open space, when the development had occurred, were there restrictions put on that development to meet a open space zoning?
I mean, yes, at least in some cases. Can I say that it was caught every time? Absolutely not. I think what Joy alluded to is the primary mechanism that's happened, and that is that when that open space layer shows up on the comprehensive plan map and the lot's over an acre in size and they want to subdivide, they're required to do it as a planned unit development. And so then as a planned unit development, they're required to dedicate 20% of the site to open space. And I think that's really been the primary mechanism is, okay, set aside 20%. And then you get smaller lot sizes in exchange, transfer the density. And then those open space tracts are often then owned by homeowners associations, in common for the development. That's the most likely mechanism that's occurred over the years.
So what happens to that afterward is that now there is not a county requirement, and there is a possibility that those open spaces can be developed.
I think it'd be hard to do that on a previous PUD. I mean, I suppose it's unlikely because they would have already transferred their density, but again, nothing's, I can't say for sure. I suppose somebody could come in and try to replat them or something, but the odds seem pretty low.
Thank you.
I just make a general comment about my experience. We have a fair number of neighborhoods out my way where they have these neighborhoods that manage or do not manage the open space. There's a number of cases where it's just a field. Occasionally they mow it. The neighborhood association is dissolved. There's not even a way to transfer it to the park district because the neighborhood association doesn't exist, or the neighborhood association doesn't allow anybody but the neighbors to use that property. So I'm not a big fan of that approach because I don't think it really works very well in the overall public's best interest. But anyway, that's my 2 cents. So, but it kind of also just say, in my mind, it's like, well, we're not really protecting open space. It's in private land anyway. So why are we designating it open space, thinking that it's going to get protected when the reality is it doesn't? So it's my 2 cents.
Well, my neighborhood has a green space. It's an HOA.
Yep.
They were protected, so to speak, under when we had an architectural guidelines, but we removed those, but we still protect because they're membership owned. So we, have constant maintenance going on these properties.
And as long as you have a good and functioning neighborhood association, that will be the case.
Yes,
But that isn't always how it plays out.
I agree. Okay, move on.
All right.
All right. Next topic is kind of shifting gears a little bit and looking at aligning the comprehensive plan and the ZDO. This is something that has already been raised today, so taking a closer look at this. So, of course, in general, the comprehensive plan lays out goals and policies that form the basis of the ZDO regulations. So we're kind of focusing on Chapter 3, the Natural Resource and Energy chapter of the comprehensive plan. The issue with the Clackamas County plan is that some of the policies are very detailed and are really worded more like code regulations, ZDO regulations, which aren't necessarily being implemented through the comprehensive plan if they're not already in the ZDO. And then certain other comprehensive plan policies say, state an objective or an aspiration to do a certain thing, but don't necessarily have corresponding regulations in the code to implement that policy. So these are kind of 2 different issues that we noticed where they're kind of out of alignment. So we kind of have 2 questions for you. And I would say definitely consider whether you think that these should be done as part of this project or as part of a future effort, because some of these might be a kind of a big lift, and especially given these other challenging things we're grappling with this project, some of these might be kind of future recommendations for future efforts by the county. So So the first question is around overly specific policies in the comprehensive plan being relocated to the ZDO. So of course, this is the benefits are removing redundancy, ensuring that the development standards are easier for staff and applicants to locate, so they wouldn't have to, look things up in the comprehensive plan if they're not in the code. It would also help ensure compliance with state law, which requires that standards for some types of applications are housed in the zoning code and not in the comprehensive plan. The cons, or one con is that new generalized policies would need to be crafted to replace the specific standards, which might not be as straightforward. I think these more detailed policies probably ended up in the comprehensive plan for a reason. So that's a challenge there. And then in the kind of, is it a pro, is it a con? Maybe it's a little bit of both. Moving development standards from the plan to the ZDO may have the effect of applying those standards to additional types of development. So this could be a pro and a con, or a con, depending on kind of how you're looking at it. But those are some things to think about there. I'll get to the next question too, and then we'll kind of discuss both questions at the same time. And the next one is, should new ZDO standards be crafted to support policies without regulations? As I mentioned, some of those policies don't have implementing standards in the code. So the benefit of crafting those new standards would ensure that the code implements the comprehensive plan policies. But crafting new regulations probably would be outside of this project, to be realistic, and would require those postcards that Jennifer keeps mentioning, that Measure 56 notice to property owners, and would involve significant amounts of outreach, because we'd be, adopting new development regulations that would apply in various areas, kind of depending on which ones we're looking at. And those would be sort of new, more specific regulations as opposed to what applies today. So two kind of big questions to think about. And I'll see if you all have any questions or thoughts on these, or whether you think that these should be placed in the parking lot for a future effort.
Can I quickly ask maybe Joy or Jennifer, why from their memories, why were there, in a sense, information in the comp plan but not in the ZDOs? I mean, what can you enlighten us?
Not really.
Oh.
I have to tell you, I doubt it was some sort of like on purpose kind of a thing. I have
right. That's what I'm wondering.
That, like, just the reality of 60 years of a comprehensive plan, and people not realizing. I think it is clear that the comp plan, at least ours, does more than just dictate the zoning code. Like, there are definitely policies in there about things that the county will do that really has nothing to do with development review, or zoning. So some of it, I think, is deliberate, but then there's those other places where it's like, boy, this really reads like it's a development code standard. Why is it buried in the comp plan? And I don't know why, but it's not really a good way to do it, I don't think.
Okay, thanks, Jennifer.
I have a question about this one, and particularly the second one. This one sounds like it's a pretty big effort, and also requires some additional work. For example, crafting new policies, or taking stuff that are implied policies in the ZDO and now making a policy section, and then yet there's still some. The second item was that we want to make sure the ZDO implements all the policies. So we've got policies that the ZDO doesn't address, if I'm understanding that correctly. So that sounds like it's a big deal, because based on what I'm hearing. And do we have a sense of how big a deal and why? What are the pros and cons of tabling it, as you're proposing? No one wants to answer that question.
Well, I'm not actually sure. Kate, this is just chapter 3 that you guys really did the deep dive on, not all 11 chapters of our comp plan, right?
Correct. Yes.
Okay.
And we did rely on a lot of commentary from earlier comments by staff in
Sure.
the comp plan. Yeah.
Sure. Yeah. Joy, were you going to say something?
Yes, this is one chapter that's very out of date that we were hoping to update with this project. However, the deep dive showed that it was bigger than we necessarily knew. And the reason that we would have to table it is for that public engagement and outreach. And that is above and beyond the scope of work that we have with MIG or MIG has with the state.
Gotcha. So this is a follow-on project then, more than likely.
It seems like it would need to be for the amount of outreach and education that we would need to do for these new regulations or new policies.
Okay. Commissioner Murphy?
Well, I wonder about enforcement issues since we're doing a makeover. And we identified this as having problems with policy. This can really confuse any kind of enforcement down the road, right? I mean, it means everything's, while it already is, you could bring in litigation and pretty much really confuse your code enforcement. This is a monster.
Yeah.
But you answered half my question too, Joy, with your first part on public engagement. We'd have to have public engagement, much more than what we think.
And just to add one thing, I mean, I think we might still have to make some more minor updates to the comprehensive plan just to make sure, the ZDO and the comprehensive plan are still generally in alignment, even though, as you can see, they're not completely in alignment today. But I think those would be a little bit more kind of targeted and strategic changes rather than this bigger overhaul that would be necessary.
Oh boy, okay. That's a good one. It's like another project for next year.
All right, next topic is kind of diving into, again, the scope, looking at the scope of this effort, the scope of these clear and objective standards and updates. And there are different approaches that you could consider. And this is kind of a refresh of what we talked about at the last meeting, but of course you're required to adopt or provide clear and objective standards for housing that's within an urban growth boundary and in certain other areas, rural residential areas, and unincorporated communities. And outside of that, you're not necessarily required to have those kind of clear and objective standards. So you have some kind of different approaches to consider. So should the clear and objective standards apply broadly to all uses? So applying kind of generally the same set of regulations to commercial development and housing and industrial development, et cetera. And in all zones. So not just rural, residential, and urban zones, but also looking at maybe not necessarily EFU zone, but other, non-rural residential zones. So that's kind of the more expansive approach, kind of more consistent standards across the board, or the more limited approach would be only applying standards where required by statute. So only certain types of development and only certain zones, or maybe some kind of combination, which I think is potentially more likely where you will end up. This is kind of the list and pros and cons that we talked about last time. With one addition, I think in the more expansive approach column, I think we added one bullet, which is that different standards for different types of uses may be needed to adequately protect resources. So the same set of regulations might not work in the same way for housing as compared to, say, industrial development, because the impacts are different, kind of the development type is potentially different. So that's one consideration. I think a big consideration is this last kind of con in the more expansive approach is that the changes could impact more properties and require additional notice. So if you're making changes that affect more types of development and more zones, then that would mean more folks would have to be involved and notified about those changes. Okay, let's look at some specific areas. So that's kind of the context that we'd like you to be the lens that we'd like you to apply to this. Unless you have a question before we move on.
Yeah, I guess the thought being, going back to the previous issue where we have this policy issues in relationship to the ZDO standards. If we were to just only focus on the statutes, which is specifically for housing only, does that mean we then have to also address these other policy issues in the ZDO? So I guess what I'm getting at is that's a big lift in itself, but we could get part of it cleaned up if we just focused on housing. That makes sense?
I'm not totally sure I'm following, but Kathy, were you following the question? Did you have an
I
answer?
think I was, and I think, we're starting out this conversation kind of talking about kind of a spectrum, right? So it's going to vary based on the type of standard that we're talking about. So and I think this makes more sense when you think about it in the context of examples, which we're about to move into.
Okay. All
So,
right.
so you might want to hold that thought, but I would say that if, for example, if we have to change the code, so right today you're regulating a riparian area, and let's say the existing standard is discretionary. You could keep applying that discretionary standard to non-residential development. That's okay. You could keep applying that to residential development outside of rural residential and urban communities. That's okay. Like you could keep applying it in EFU or wherever else it applies. So I think, this idea of we need to fix it in certain areas and for certain uses, most definitely. You can keep what you have, even if it weren't perfectly clear and objective in other circumstances. And so that's that trade-off. It's like, and again, that trade-off may play out differently for each of the different overlays and for each of the different sets of standards.
Yeah, I understand that part. I guess what I was getting to is this aligning the comprehensive plan and the ZZO item. It was when we last talked about it, it sounded like it was just too big of a scope to address with the current scope. Yet there's likely some policies or some overlap in there that are specific to housing that would have to be addressed, is what I was getting at.
Yeah. At a minimum, I think we see this project, if we were to define success, we would ensure that you have clear and objective regulations based on your current regulation, right? So whatever you're currently regulating today, that you have a clear and objective path for housing in the areas that you absolutely have to have it. That is a minimum, like success. And so if you're not currently regulating it because it's a comp plan policy that doesn't currently have a corresponding regulation, that's a different question, I think. Converting the existing regulatory framework for housing where it's required to be clear and objective is kind of the minimum target for success here. And I'm sure that we want to do more than that. We want to, also improve the code in other circumstances and do what other things we can do. But that would be the minimum I would think we'd want to try and accomplish.
Yeah. Okay. Thank you. Commissioner Lee, see your hands up.
Yeah, thank you. I'm hearing a lot of the discussion and a lot of the concerns. It seems to center around unintended consequences of changing the code in the way we've been discussing it. And so I'm leaning towards the limited approach, the more limited approach for that reason, that the amendments would be fairly easy to write and the impacts would only be on the properties as necessary. And then cherry pick maybe some of the low-hanging fruit that we can modify and combine and or make more consistent, but yet avoid those ones that are having the unintended consequences. So that's my only comment. That's the way I'm leaning.
Yeah, good thought. Commissioner Wilson. You're on mute.
Okay.
There you go.
What I'm seeing here, and based upon what I've been hearing, a lot of this stuff is just like kicking the can down the road, to use a proverbial acronym or whatever, that we need to address these issues now. And I'm more for making the changes across all of the areas that we've been talking about, rather than kicking this can down the road again and having to come back and revisit this stuff. When I came on board with the commission here, we had issues with code enforcement. We still have those issues, and I think some of those issues that we have not only are related to personnel requirements, but also because we have these vague things going on in our code and our regulations. I would like to see us start addressing all of these things and make them much simpler. I think that would help not only with the applicants, but also with our staff that is trying to, address these applications and having these discretionary things that they keep coming up with that they've got to address. So that's my thoughts. And I really appreciate the fact that we're trying to address some of this and make it more comprehensive and more objective. But if we keep taking a piece of it here and working on it and then delaying the rest of it, I think we're just pushing the can down the road again.
Yeah.
That's just my thoughts.
Yeah. I tend to agree with you. I think the dilemma here is we don't have the scope and the budget to do everything, to do that is what my takeaway right now. So this is probably going to come down to, well, what can we accomplish now? And then how do we lobby to make sure we keep the momentum to finish up the rest that we weren't able to address. It's kind of how I see where it's going. Okay, Joy, I see you have your hand up.
Hearing your discussion about your concern of losing the protection from 1000, the stream and river corridors protected by 1002, and the wetlands that are not mapped currently, having a piece that could address those four development types that are not housing may be in line with what Commissioner Lee just talked about. How there are areas where we might need the ability for a commercial development to protect a wetland that is found during the development process or during the review process. And so that is what I think about after hearing all of your discussion tonight.
So it sounds like to me, one of the takeaways will be to go back and look at this, and based on all these various things, and you may come back with a recommendation that says, in some areas it doesn't make sense to, yes, they may need to be addressed, but they may need to be addressed differently than how we approach housing, for example. So I suspect that's what we'll be hearing in the future, based on the feedback you're getting. So your point's a good one, Joy. I think that kind of illustrates how this might play out, or your recommendations going forward. All right, it's running late here, so I want to try to get through the rest of this if we can. Are there any more questions on this last item?
Well, we have several slides that kind of take a closer look at that aren't in this kind of consolidation, simplification realm, but really just we need to make these sections of the code clear and objective, and there's some challenges to doing that.
Yeah.
And there's some considerations. So I'm just going to jump forward really quickly. There's 3 substantive questions. I think these 3 are also things that staff mentioned wanting to get some direction from the Board of Commissioners on, because they're kind of bigger policy questions with potentially bigger, more controversial topics. So we could maybe kind of jump through these quickly, and you can decide whether or not you want to discuss them further. But I think we would want to get some initial sort of policy direction from the board as well. But should we try to get through them?
Sure.
Okay. All right. So the first one, trees and wooded areas. This is a section that applies throughout the county and requires groves of trees to be incorporated into development wherever feasible. So using very kind of loose discretionary language, and includes standards for avoiding substantial disturbance of tree groves and other subjective requirements. So again, kind of vague language, pretty discretionary, kind of challenging to implement. So if we were to craft clear and objective standards for trees in wooded areas, which might look something like a tree protection or a tree preservation requirement, that would make the code simpler, easier to implement because we'd have these, specific regulations to implement. Changes could provide standards for the protection of distinctive urban forests, which are also referenced in the open space and parks chapter of the code, and would remove that ambiguous language that's not currently implemented or maybe not implemented very effectively. On the challenge side, tree protection standards might cause significant public controversy. I've heard that's something it's a topic that's been controversial in the county in the past. And it's really pretty difficult to craft clear and objective tree protection standards. I mean, in other jurisdictions, that's often kind of its own project, like a new tree code is kind of its own undertaking. So that's a challenging one. I don't know if there's kind of initial quick thoughts on this that you want to share before we tackle the next one.
Just
I think
quick.
you're right.
Oh,
Challenge one. Tammy, you have a question?
just quick.
Yeah.
So different between urban and rural. So can you speak to that, please?
Geez, I might look to Joy to see how maybe this is played out in those 2 contexts.
It's played out more commonly on discretionary land use processes, like conditional uses. And less on you're building a single family home. However, there is areas where a single family home would trigger this.
I mean, I have a friend who, has property kind of in unincorporated but urban, and this has been huge. And so I don't know without a true tree ordinance how we could go down this path. This is one I really thought about, read, struggled with, without you can or you can't. Very clear and objective what you can or can't do with trees. I don't know how you would get your arms around this. Now, that being said, I wouldn't want to be on the Lake Oswego City Board right now because, they're getting sued to death. trees are falling that were requested to take down because they were dangerous, and the city said, no, doesn't meet the ordinance. And then people, well, one person died and a lot of buildings were crushed. And so, I mean, this is really a sensitive topic, and I don't disagree that something needs to be done, but I don't know how you would do it. And well, anyway, this is, you said it, Kate, it's super sensitive, but there's one side of the coin. If you've got the ordinance and people can't manage dangerous trees, there's a whole set of risk. To the other side, you have and people are just mowing down trees and putting up subdivisions, which is just a crime. So I think it's totally another project. And that's it. Thank you.
Thank you.
Yeah, I tend to agree with Tammy on that one. It's a slippery slope to try to tackle this one right now. You might, especially particularly as it relates to housing. I mean, how do you protect a grove of trees at the expense of, okay, that means I can't put in as many houses in, when the whole objective of this thing is to create more housing. So it's going to lean towards taking the trees down anyway, if that's our ultimate goal. So anyway, Commissioner Murphy, you have a comment, I see.
There we go. Yes, I do. There is a value to trees in neighborhoods, as we know. They do bring a calming effect. But then again, your number one con, tree protection standards may cause significant public controversy. You know it will. And, we'd have a pretty tough fight. I know in our neighborhood, we had over 100 properties treated with tree removal, simply because the trees grew and they were just too dangerous, or they're dying because of climate change, so to speak. We saw the hemlocks going, we see the cedars dying out, we see the Doug firs dying out. So trees were coming down everywhere.
Yeah.
This is a tough one. I think it's time. I think just like what Tammy said, we need to take a look at this.
Okay.
Okay. The next one might not be any easier to to consider, but so deer and elk winter range. This is related to Goal 5 habitat protections. And kind of the whole gist of this section of code is that within the winter range below 3,000 feet in elevation, development shall be designed to minimize adverse wildlife impacts. And that's the extent of it. I see there's a hand up, but I'll just show kind of the maps that show that the blue outline area, that's where these regulations apply. So as you can see, there is a lot of land that is subject to the clear and objective requirements. Rural residential, I cannot say that, zones where this, they need to have clear and objective regulations. And then county staff also did a little bit of calculation to show how many acres of land, again, need to have clear and objective regulations that are within this area. And as you can see, there's a significant amount of land that would be subject to these requirements. This chart doesn't show other areas that are not, subject to the clear and objective requirements, but there's a ton of EFU land, of course, and other zones that would also be within the deer and elk winter range. But I'll pause there. We do have a pros and cons slide, but I want to see if Commissioner Stevens, you have a comment.
This one really, I scratched my head because I really couldn't get the objective here. And I know Commissioner Murphy will have probably a lot more input on this because it's really his area. I'm only at 700 feet here, but I'm incredibly rural. I am surrounded by literally thousands of acres of timber. I have deer and elk coming out of my ears, and we've got barns and we've got fences and we've got houses, and it doesn't seem to impact them. They sleep in my yard and they eat my pastures, and they quite frankly eat my hay in the barn. So I've never really understood this winter range. I mean, yeah, they come down and they eat and they sleep and they move, But unless Commissioner Murphy has input on this, I've never seen anything we've done other than roads. You know, I've seen some dead ones alongside the road impact deer and elk. If they want to sleep in your yard, believe you me, they will do that. So can anyone enlighten me on the value of this ordinance? Because I don't understand it. Thank you.
That's a great question. I I am certainly not an expert on this topic. I don't know if anyone else knows more. Commissioner Murphy?
Yes, thank you. Thank you, Tammy, for dumping this on me. Is Fish and Wildlife any part of this decision? I think Fish
Yes.
and Wildlife would play a huge part in this. You know, from what I see, like Tammy, they're everywhere. They're coming into the neighborhoods, obviously, because there's things to eat. I was given a bid for a roof up on Coleman Road. And I was talking to this guy who had 60 acres, and I commented on the game fence next door, and it was a 12-foot fence surrounding his neighborhood's property. The guy had, I think, raspberries. And this guy said, "Oh, I used to raise raspberries." He goes, "Oh, God, you know, most of the year things would be great." Oh, you know, it looked like a fantastic year. I wake up one morning and there'd be 60 elk and they're just taking the place apart. And we just had to get out of the raspberry business because they showed up every year and just destroyed our crops. He goes, you know, this is where they winter. So it's already established. It's I don't know what else we could do.
And go to the Oregon coast. I mean,
Oh,
they tell you don't walk your dog because the elk will kill it. So I'm not sure how building homes or even fences or barns, believe me, it doesn't stop them here, makes any difference. And I love Commissioner Murphy's idea of asking Fish and Wildlife because maybe they've got an idea because it might help me here out here protecting my raspberries.
And Joy mentioned we do have a meeting set up with Fish and Wildlife, and so I think that's a question that we can ask them is how other jurisdictions are dealing with this. We've had some experience in other places like Deschutes County, which is kind of a different context, and they had a different kind of base code to work with. But I think the real question here is you are required to protect deer and elk habitat. Your current standards, of course, are very discretionary. What can we do to make them clear and objective? And it is a little bit challenging, and we can show the pros and cons on the next slide. But I want to pause and see if Commissioner Wilson has a question or a comment.
Yeah, I have a comment. I have a acre of property here in Oak Grove, which is just outside of Milwaukee, and I have deer in my backyard all the time. I love it. I love it. I love looking out there and seeing those deer out there. They're eating the grass. They're doing whatever, and I don't have any objection to this. I think it's great.
Great, thank you.
All right.
Go ahead.
Go ahead. I wanted you to move on. So go ahead.
Okay, perfect. Yeah, so we need to craft clear and objective standards. Those regulations could provide better protection for this habitat, although we're hearing from some of you that you're not concerned about the level of protection. But because the existing language is pretty loose, pretty discretionary, it's maybe not as effective at ensuring protections. Again, these, applying new, more restrictive standards to properties, it would potentially be controversial. You'd have to send Measure 56 notice. And it's not necessarily really straightforward to take this one, kind of vague standard and turn it into more specific standards. Although there are some recommendations from the ESEE analysis that was done many years ago that could be incorporated into the code. And there's some other ideas we could look at from other counties. But I think this is a larger question because it would be potentially making a change to your Goal 5 program to protect this resource. So that could be kind of a larger undertaking than some of the other sections. One consideration is that maybe that more limited approach to the clear and objective standards would be one opportunity to kind of narrow the scope of those potential challenges. So maybe focusing only on housing and only on those rural residential and unincorporated community areas.
Yeah.
Kathy, anything to add to that?
Yeah, I was just going to kind of follow up. I mean, it's hard to know what rural residential regulations could do that would mitigate the impact. Sometimes there's like a placement of the house relative to the street and so forth. But I think, one of the things to keep in mind is that, the zoning itself, having the low density residential in those areas was kind of part of preserving, habitat and, the rural nature of the area. So, I think that one could make an argument that the primary protection is actually provided by the fact that these are relatively low density areas, and that is kind of the nature of the protection.
Commissioner Murphy, see your hands up again.
Just a brainstorm, could this be incorporated into the RSCA somehow?
An interesting idea. I think the extent of the area that's subject to these requirements is quite a bit broader than this river and stream corridors. But I like the creative thinking.
Think on it.
In some areas, the deer and elk winter range mirrors the streams nicely. And in some areas, it's much wider.
Well, you're going to have fun with this one. Go ahead.
This is all just a barrel of laughs at the end of this presentation here.
I'm sorry. I'm just trying to, it's getting late. I'm trying to.
Yes, I know.
It's a tough one. I'm scratching my head. It's like, okay, I'm not sure where I am on this one. It isn't really even an issue, other than what's in the code isn't clear and objective.
Yeah.
Well, whatever we write, is it going to make a difference? Probably not. But whatever.
And I mean, staff has noted that implementation has been somewhat inconsistent as well. So I think to your point, it might not make a huge difference.
Yeah. Yeah. That's yeah.
It really comes
If only
down to what is
only those deer and elk would understand our zoning ordinances, we wouldn't have this problem. Okay, sorry, I'm being a smart aleck. Let's move on.
Okay, the last one is it's a little bit different, but it's something that Joy already mentioned. So the mass movement hazard areas, currently the county is relying on maps that date from the 1970s, I guess. But there is much more current data that has been provided by Dogami, the SLIDO, Statewide Landslide Information Database for Oregon. So the question is, should those newer maps be adopted? So let's see. This would potentially add areas where modern mapping has identified potential landslide hazards. So to the concerns about, protecting against landslides, having more up-to-date information could be very helpful. Removes areas that are no longer identified as having landslide areas as well. So if it's not really an issue on your property, maybe you don't have to deal with these extra hurdles because they don't really apply anymore. Again, the con is Measure 56 notice raises its ugly head again, where, applying new regulations to areas that aren't currently regulated, you do have to notify the property owners, and that is potentially challenging. I'll turn it over for comments.
I think who was first? Were you up first, Tammy?
I am. I know I don't have to repeat it. I'm very passionate about this because developers, even when warned that this is a historic landslide area, develop. And, yes, there are permits that you have to get, like conditional use, and you have to do everything right. And when people do that, then homes don't slide into valleys. But my 100,000% belief is that we have to use the most current Dogami LiDAR maps in order, and whether we have to notify people or not, that has to be used. This is technology that exists. These historic landsides exist. I mean, if you doubt me, go down Holly Lane in Oregon City and see the homes that slid down into the valley, or the apartments, good heavens, right there on Beaver Creek Road. Those were all built on historic landslides. They should never have been built. And the people that built got nothing. Literally, there are people that are paying mortgages on homes that were destroyed. That's wrong. I mean, it should never be allowed. So my answer to this one is absolutely positively. I don't care how many notices we have to give. This is the right thing to do for our citizens. And I'll stop. I'm off my soapbox, but thank you for letting me.
Okay. Commissioner Lee, I think you were second.
Yeah, I was, and I want to echo Commissioner Stevens' concerns 100%, maybe even 1,000%. You know, human life safety as an engineer is number one for me. I live it every day, and we can't do enough to identify these hazard areas, notify the public, and if we have to, you know, send those Measure 56 notices out. I'm sorry, but we should be forcing development onto areas that are safe to develop and not areas where they shouldn't be developed. Pretty obvious. So I'm in favor of it. Thank you.
Commissioner Murphy?
Thanks.
Thanks, Tom. Yeah, I echoing Tammy and Brian. I was on a timber sale committee for Clackamas County's timber harvest, and I opposed the cutting up behind my place, which is about a 60% grade, because of Slido identifies this area as a historic slide zone. I have a map right behind me that's a LiDAR of the Mount Hood corridor and has all the slides on it. I'm built on a slide. And it's kind of scary when we have rains like right now going on for the people that live under these areas. I mean, this is a possibility that not only could the hill cut loose with a house on it, but what's below, where's that debris going to go? So it is a concern, definitely. I'm done.
All right, Commissioner Satter?
I was just going to agree with Tammy and Brian and Murph, especially when we're going through this atmospheric rain event where we live. It's just the nature of the beast. We get a lot of rain, and with all the development that has been happening, it's changed the landscape of these dangers. And as far as the notices, it's not going to be like getting the same notice, you can't build this on your property. This is something property owners are gonna want to know about.
Okay. Anything? Guess I'll throw in my 2 cents. In my mind, I think it's a crime that they aren't keeping people abreast of the hazards in their neighborhoods. And so to me, there's a potential liability to the county if they don't address this issue. At some point, someone builds on a land that shouldn't have been built on. There's a fatality or death, and the county knew better. I could see a lawsuit over this one if we don't address it, besides thinking it's the right thing to do. So, okay, any other comments or questions?
I just wanted to see if Joy, because I know Joy had prepared some maps to support this topic. So Joy, did you want to show those, or do you think we've got clear enough?
I think
Clearly
we
got
have clear guidance.
Yeah.
Yeah,
I think we
agree.
will stand on that one.
Okay.
Okay.
Well, that's our last slide, so I'm going to stop sharing.
Okay.
Yeah, thank you for all the great discussion and feedback. Obviously, this is These are some really difficult issues. So appreciate your time. I know it's been it's been a long one. So thanks for sticking with us and continuing to stay engaged.
Yeah. Thanks for sticking with us.
And Kate, again, amazing job to
Yeah.
get your arms around this the way you did. I read it and was like, oh, I'm ready. And I had no idea how we were going to do this. So well done. I mean, bravo. That was really hard. And I feel like we've done the best job because you did this for us. So thank you.
Of course. And it was definitely a team effort. Joy and Jennifer and Kathy all contributed quite a bit. So appreciate that. And Karen too. Can't forget Karen. She's been quiet over there, but she's a big part of this as well.
Well, it's no easy task. We just get to sit back and make comments. You're the ones who have to figure out the appropriate language and how to say it in a way that's going to work. So you still got a lot of work ahead of you. So, but I think you've done a good job of kind of identifying the issues, giving us some things to think about. And it's not a nice, easy black and white kind of thing. It's really complicated. So it'll be interesting to see how this plays out and what else is going to follow it, because it looks like we've kind of just hit the tip of the iceberg here today in terms of what needs to be addressed. So this could be with us for a while, I think. Am I right, Jennifer?
But it's a good thing. You got a clean house.
Absolutely.
It's a good thing.
It's not easy, but you just got to do it. Roll up your sleeves. Okay. Anything that you want to share with us regarding this little project you're working on, or are we done with that? Oh, Commissioner Wilson, you have you have your hand up. You want to make a comment?
Yes, I do. I want to address Jennifer. You did a great job here with a limited staff, and I can understand why we need these consultants in here to help you. We got a big project here. We've got, I'm looking at this as 30 years of just delaying action, and I'm seeing these maps that are not been updated and all of that. You guys have done a wonderful job with limited resources, both, personnel and also with the data that you've got, trying to keep up with this. And, we're left with something here that we have to work and address, and it's going to take some time. And thank you very much for all your work and all your work, your people's work. It's amazing to me. I've been on the commission here for almost 12 years, and boy, we've had a lot of work to do, and it just seems like we keep kicking the can down the road and not addressing things properly. This looks like a way to do it. And thank you very much.
And we have great consultants. Thank you very much, Kate and Catherine. I appreciate your time tonight.
Yep, I agree.
Thanks. Have a good night.
Okay.
Bye.
Thank you all. We do have a couple other items on the agenda we need to address. There's minutes from the last meeting.
I make a motion to accept the minutes as written.
Do we have a second?
Second.
Okay. I'm just going to jump to the vote here. So it's been moved and seconded. So I'm going to take a roll call vote. So we'll start putting down the way they show up on my screen. So Commissioner Murphy.
Yes.
Commissioner, my screen keeps popping around here. Commissioner Wilson.
Affirmative. Yes.
Commissioner Founds.
Yes.
Commissioner Stevens.
Yes.
Commissioner Lee.
Yes.
Commissioner Satter.
I'm going to abstain from voting on this because I wasn't there at that meeting.
Oh, the previous one? Oh,
Yeah.
that's true. Good point. Okay. I think Commissioner Lopes had to leave. So So that's it. So I guess it passes.
Did you vote? Tom,
Oh,
did you vote?
I'm sorry. Jeez. No, I'll vote yes also.
Okay, think it passes, yes.
Sorry. I was so ready to get through this. I forgot about myself.
Exactly. That's okay.
Any schedule reviews next? According to this, would you hand it out? We only have one more meeting, then we're done next year.
Yeah. So you're off. You're off for the rest of the year. Everybody
Yeah.
can take the rest of the year off.
Yeah, good.
And we're not going to have the first meeting in January. So
Yeah.
we'll be back January, is it the 26th, I
Yeah.
believe?
Yep.
Martha and potentially Taylor will be back with a comp plan amendment and zone
Okay.
change on the 26th. Yeah.
And I will be in the mountains of Patagonia, Argentina, riding horses
Oh,
Wow.
on January 26th. So unless I can find cell service, I can tell you right now, I'm not going to or I will not be able to attend the January 26th.
Okay.
Darn.
Well, we need a quorum for that one, so we need 5. So please, anybody else who can't make it, please do let Darcy know that as soon as possible.
okay. And right now, the rest of the calendar is open. So we don't
We're
know.
going to have lots of stuff. It's just not specifically calendared yet.
I know.
Yes, we'll keep you busy, I promise.
Okay, any other business? I'm going to make a suggestion. We had a topic that was introduced earlier this evening. In the interest of, it's late, it's been a long meeting. Maybe we could have a conversation about that at a future meeting if there's a desire to do so. So I don't see anyone saying no to that. So,
No.
and I don't know if everyone feels it's worth having a conversation about either. So maybe we could pull the group offline and see if it's something we want to bring and have a conversation about in the future. Okay.
Mhm.
Any other business?
Happy holidays and happy new year. And
Well, we won't see you for a while off
no,
Alabama.
no, not till February, right? Yeah. I'm confident Jennifer's gonna make our 2026 year busy. If 2026 looks anything like the end of 2025, we're going to be very busy.
Looks like,
It's
You
great.
guys to work.
Yeah.
yeah,
Right.
kind of like the good old days, huh? Tammy?
Yes, exactly. Man, we were
When we would meet several times a month, actually.
yes, in person though. That's
Oh, in
always hard.
That's right.
All right.
Other than that,
Okay. Well, same to all of you. Have a nice holiday season, and we'll see you next year.
next year.
All righty.
Good night, everyone.
Good night, everyone.
Bye.
Merry Christmas.
Merry Christmas.
Merry Christmas.